You suffered terrible injury as a result of a doctor violating the basic standards of medical care, and you brought a lawsuit trying to seek compensation and money for all the harms and losses you suffered. But now, as your case is getting to trial, all the parties agree to try and settle this case. And now, during the course of settlement discussions, one of your conditions to settle this case is you want the doctor to provide you with a written apology. Will they do that? Will the defense agree to provide you with a written apology? You want to know the answer? Come join me for a moment as I explore and explain whether or not you'll get what you want as part of this settlement agreement. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, you've brought a lawsuit. It's been going on for 2 or 3 years against a doctor who you believe caused you significant injury. And now you're getting close to trial. The two sides have now agreed to start talking about possible settlement negotiations. And now, during the course of settlement negotiations, one of your biggest conditions is, hey, I want an apology letter from the doctor, personally apologizing for what he did, causing me all these injuries. The first gut reaction the defense attorney is likely going to have is, absolutely not. We will not do that. You want to know why? Because the moment we give the patient such a settlement letter, now, how do we know that's not going to make its way up online? How do we know it's not going to wind up on somebody's website? How do we know she's not going to call the newspapers to publicize this? When the attorneys reach an agreement, when the litigants reach an agreement, typically in a medical malpractice case, they don't want any publicity associated with it. So that will be a condition, likely a condition, as part of a settlement. Hey, listen, you want to settle this case? You cannot publicize what goes on here. Also, as part of the settlement agreement, the defense turns around and says, listen, we agree to pay you a certain amount of money, but we are not going to legally admit we did anything wrong. Now, that's a significant issue. So in the settlement agreement papers, it says this is not an acknowledgement of any wrongdoing. So do you think they're going to now be willing to give you a piece of paper written by the doctor, handwritten or typed, whatever, that says, I apologize to you, Mrs. Jones, for causing you harm, for doing wrong by you, and now giving lengthy reason why? Do you think that's really going to happen? The reality is that it's not going to happen. As an alternative, the defense attorney might suggest, you know what? We'll all get on a conference call and the doctor will personally apologize to you on this call. Will that be acceptable to you? And now it's either yes or no. And if the answer is no, then now maybe you can't settle this case. Now maybe you have to try the case and let a jury decide whether you are more likely right than wrong. So why do I share this interesting viewpoint with you? I share it just to give you an insight and an understanding into what could happen, and sometimes has happened, during the course of a medical malpractice case here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you haven't done so yet because you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.